Okay, so welcome back. We are gonna, in this, excuse me, in this segment, we will talk about technology transactions. Now, we've had some panels that have talked about, the deals and the contracts and that sort of thing. This is gonna be not, do you hear feedback over there? Is there any feedback? No, okay. So this is not going to go over all the stuff that we've done already, but what it really is intended to do is to talk about terms. What are you looking for in the contract? What do you need to be in the contract? We're going to talk language, where we hope you guys have questions and experiences and can share those with us, and we'll have a robust conversation about what it is that you should be looking for, requiring, watching out for in your AI-related transactions. So let me introduce the panel from left to right. We have John Zavedas, and John is Vice President and Managing Legal Counsel for T. Rowe Price. Thanks for coming back. It's always good to see you, John.
Likewise, thank you.
Next to John, we have Chris Forstner, and Chris is a partner at Troutman Pepper, and he also was at one point in time a member of the Capital One Mafia, as I kind of say. All you guys stay together. You're great friends, and you've been good friends to me. Chris was Chief IP Counsel at Capital One before joining Troutman Pepper. Thanks for being here, Chris.
Thank you.
And then last but not least, we have Tyler Rhodes, who is Assistant General Counsel at Capital One, where he leads, provides business counsel and legal advice for enterprise technologies. So it's great to have you all here. What I'd like to do is start the conversation like I've done so far with each of the panels, just to get us going, to get in the flow of it, to get you to tell me what it is that you think the audience should be focusing on, big picture, before we really roll up our sleeves and hit the ground running. So let's just go in the order I introduced you. John, what do you want people to be thinking about here right now as we start the conversation?
Yeah, absolutely. First off, thank you, Gene, for inviting us and having us here today. I think most importantly is that it's very important to have the business appreciate that an AI contract isn't identical to a regular technological contract that we have dealt with day in, day out for decades right now. There are many different complications depending on the potential use case that we have, that we need to ensure that there's proper mechanisms, contractual mechanisms, to best protect the business objectives as well as the end goal of how we want to utilize that output. So that's what I would say.
Great. Thanks a lot, John. Chris, let's go to you for your preliminary thoughts.
Yeah, so I think there's a lot to take in with this new renewed focus on AI technologies. As many panels have said before us, that there are artificial intelligence technologies have been used and employed in our clients for many years and for a variety of different purposes. But what we've seen over the last, I would say, 12 to 18 months since ChatGPT really had the big splash, is a lot of other companies that really weren't invested in and resourcing towards AI technologies wanting to get in. It's the next thing that they're getting pressure from a lot of their executives to do. So what we're finding is a lot of our in-house clients that may not be technologists, that may be more generalists, are being asked to tackle these questions and thinking that it's just a simple, like it's a software agreement or something very basic that they have seen in the past, but not truly understanding the technologies. And so I would say one of the things that becomes really incumbent upon all of us that are going to be playing in the space, to be able to properly advise and kind of understand the puts and takes and the decisions that you're making, you really need to kind of dive in and understand the technology at a more granular level, to understand what your clients are intending to do with the technology, what the actual provider is going to give to you, and we're going to get into a lot of these other these kind of nits and smaller areas, but really to kind of understand that what that means, because it's as John was just saying, it's not the same as just a standard contract, and to really be able to advise and give good counsel, you really do need to understand the technology better. So it's worth that investment of time.
Great, thanks a lot, Chris. And last but not least, Tyler.
I would suggest that we as a legal profession need to approach these issues with a great deal of humility. There's a lot of ongoing litigation, there's some uncertainty in the legal landscape, and at the same time you have technology moving at such a rapid pace. And so approaching each of these transactions almost de novo, because people are using terms in different ways to mean different things. And so just approaching all of these with the utmost humility to ensure that we are identifying the right risks and solving them. And then after you embrace that humility, embrace the fun and the problem solving and creativity that these transactions can create.
Great. Thank you very much for that introduction, everybody. So now let's pick up and start with where Tyler took us to the risks area. And as AI and generative AI have advanced, there's all kinds of now legal risks that you need to be aware of and solving for as you're looking at the various relationships and agreements and that sort of thing. What in your mind, what are we talking about? What should people be focusing on or keep in mind? Chris, you want to start?
Yeah, at a high level, the things that we want to make sure of. Well, I always step back to kind of like true IP objectives. In my world, it's one, make sure you protect the house, and then two, don't step on the toes of other people. And if you kind of apply those IP principles to what's happening in these AI transactions, I think you can kind of think about a lot of these risks. It comes down to, who's owning all of the inputs and outputs that are going to be generated from the applications that your clients want to use, because presumably there's a business case for it. There's some efficiency that they're going to gather from it. So we really need to be kind of considering ownership and who's going to own the technology, who's going to own the underlying IP rights. Then you're also going to really need to make sure and focus on that the provider who's giving rights to you, what those encompass, restrictions that are going to be placed upon you, and then making sure that they have the right to give things to you, so that one day you're not going to be hit with an infringement risk from various data providers or IP-related risks. So again, making sure that you're protecting what you need to protect from an IP perspective, and making sure that what you're getting is something where you're going to be protected as well.
Okay, great. Excuse me, Tyler. Any thoughts? What kind of risks are?
Yeah, I agree with everything Chris just said, except I step back from all of these AI transactions, and we are in a moment in time in which there is so much money to be made in this space than human history. Whenever there's lots of money to be made, there's lots of opportunity for people to commit fraud. And so, I even pressure from the outset, is this actually AI? And so, or is a salesperson purporting to sell something that is not in fact AI because they'd like to capitalize on the hot buzzword of the moment? And that's incredibly important to us as a profession, because let's face it, AI engineers, incredibly scarce resource, and the last thing we want to do is waste time on something that is not what it purports to be.
Yeah.
Okay, good. John?
I was going to just back that up, concur as to how important it is to do that due diligence on that company, right? And to due diligence on what your business objective is, because what happens in at least my world is that the business comes like, hey, we have a service provider that is going to solve X, right? Or we have this business problem and we believe this is the best model that we should be deploying or whatnot. And just sitting back and just trying to figure out where in the entire business priorities does this actually fit? And is this something that is, a big revolutionary thing that is going to transform our company, transform the industry, or is it simply an efficiency type of problem that we have? And as a result, how should we deploy that AI system? Are we talking about a SaaS model? Are we talking about an on-prem model, utilizing a cloud environment whereby we gain access to proprietary AI models? Each and every one of them have different risk profiles, and each and every one of them has a different application to the business objective. So fully understanding what that business objective is, and then not immediately, acquiescing to that. Okay, great. We want to, utilize ChatGPT. What other tools within the organization could we be leveraging? And that is, I think, a big job of us, is mitigating risk by fully understanding and appreciating what the entire technological environment is at your firm. There's different pockets playing with AI, and getting them to have conversations with one another is a way to significantly reduce risk and not expand the amount of AI sandboxes or AI prod environments that we have with third parties. So
I think one other thing I would add to that is, we're seeing so many clients that almost feel pressured to do something, to put something in the AI space so they can check a box. There's like a bingo board somewhere that they need to check that they're doing something in AI. And I think it's incumbent upon all of the lawyers to like really kind of take a moment, take a breath, and be like, does this actually make sense? When you look at a contract and all of these are, several pages long and have all kinds of obligations, and these obligations can run for quite some time. And perhaps once you see a contract for the first time, maybe there's not a clear way to unwind this, And so you really have to understand, does this make sense? Is this something that for this check the box perhaps type of moment that we really want to get into because of all the other attenuating obligations and risks it could create?
Mm-hmm. So let's pivot now to the actual agreements that you've seen and where AI has been involved. So, like, give us for instance, what are we talking about? I mean, we can probably hypothesize, but let's not hypothesize. Let's try and talk about nitty gritty. And Chris, we can lead off with you if you want. Where do you see AI rearing its head in agreements of what kind?
Clients that want to license an AI solution, that want to bring it in-house to do some various function or task. That's the primary one that I'm seeing today. And then I'm also seeing clients that want to license it to be able to put it on top of an existing product or an offering that they are already having to. And they want to license the underlying technology, incorporate it, and then put out their own product, and basically need to understand all the implications of when they've incorporated it into their product, and now they're ingesting their own customer data into that, operating on that, processing it, delivering back inputs, ownership of all of the inputs and outputs, and the data rights that go along with that. Those are the two things that I'm seeing the most right now, is clients that just want to leverage it for internal use, and then clients that want to layer it on top of something that they're already offering to their clients.
I was going to say, that's exactly right. And at a higher level, we're seeing the use cases under essentially three buckets, right? Content creation. We all understand that. Creating campaign pitches. Our agencies love now to find efficiencies on the way they can visualize the ideas in a potential advertising campaign, or creation of press releases or any materials that we want to use externally, sales materials, etc. But also there's the consumption, right? In the investment management industry, we're looking at a lot of data, a lot of research that is not only publicly available from the EDGAR website, SEC website, or from the actual investor relations pages and whatnot, but proprietary research that our teams have done, that have collected, that there's just swarms of data that we need to consume, summarize, and find signals through. So we're seeing a lot of that. And then, of course, content characterization. So taking, a prospectus or an annual report that's year over year, and just finding tonal changes, or the leveraging of different words that could imply different things that obviously us as humans currently do, but AI just makes it faster and at a larger scale. So these are the types of things we're seeing from a transactional standpoint.
Okay, great. And Tyler?
Yeah, so seeing transactions that fall within three different models. The first, you're seeking access to a model to then hopefully fine-tune that model or train that model on your own data. Mm-hmm. Third model, where I'll say it's more of an efficiency play, but it's a SaaS solution generally that leverages Gen AI or some sort of AI solution to create some sort of benefit. And then the third is the AI isn't really the subject of the transaction, but it's in the background. So the vendor, and I think someone mentioned it in the risk management panel, surprisingly tells you, oh, we might be providing janitorial services, but we're now suddenly using Gen AI to assist with that. And so it's not the core subject, but it obviously then can raise issues when it crops up.
Right, right. And I suspect that this is like with every company could have a trademark and a trade secret. Every company could really be using Gen AI for some reason, right? You know, to identify customers, to identify opportunities, marketplaces. You know, is that right? Is that what you're saying?
Yeah, I don't know a company out there right now that's not trying to figure out a way to leverage the generative AI tools that are out there in some way to gain some type of efficiency right now. I mean, we've all seen the Wall Street Journal articles, and every prognosticator that's saying that this is going to replace jobs and you know, make everything move faster, quicker. But so people are playing with it for sure. Content creators are playing with it. Even within our own law firm, we have our own private instance where we're using it to test on marketing materials and things of that sort. And I don't think it's, you know, too far off where we're seeing these tools being, you know, advertised to us, where it's going to be used in, you know, in the true delivery of legal services and research and other areas like that, brief writing, things of that nature that are coming, that I think it's going to be very relevant. But yeah, I'm not aware of a client or a company that's not trying to figure out some way to make use of it now, for right or for wrong.
Yeah.
And if you're not using it, someone in your supply chain is using it. And you will not convince me otherwise that like it's just that prevalent right now. So in some way you are exposed to it.
And what's the risk there?
Oh,
I mean, there's some of the risk you don't even know about, right?
well, the risk of not knowing is its own risk, but I mean, it's a lot of the same risks of you engaging with the vendor directly, because if that vendor has your data, is performing tasks on your behalf, then presumably the AXO emissions of that vendor working through a subcontractor can drive to you as a company. And so the risks are the same, even though it may not be as proximate.
And this is where a point that I think both of you have made so far, that I think really becomes important for any type of transaction that's involving artificial intelligence. And I know other panels have mentioned this as well, but making sure that you do your diligence on the counterparties that you're working with and understanding, you know, who they are, where their data is coming from, where their models have been, you know, created from, how they've been developed, and understanding who are their sub-processors if you know, any type of customer data is going to be touched, and hopefully not, but you know, just making sure that you understand who that party is on the other side, I think becomes very important. And, you know, working in contractual protections that force, you know, all the things that you're asking of the provider down the provider subchain, and making sure that is provided for as well.
Yeah. John, do you have any thoughts before
No,
I mean, because this is again, it is scary with, you know, the risk that you know, the risk that you don't know, and there's so much out there, and you know, and just what you're saying, Chris, it made me think again, going back to what we heard about yesterday about whether it be the copyrights or where the data sets and training sets come from and everything. I just don't, and maybe I can get each of you to talk about this, you know, from a transactional perspective. If somebody came to you and said, hey, I need to do a deal to get training data, and you're like, okay, well, I need to know a little bit more. Where are you getting it from? Who is it from? You know, blah, blah, you know, what is the risk that it's not verifiable or accurate, et cetera, et cetera. I mean, what would you tell people? I mean, because I think to myself, I would want the most accurate, best, thorough, complete data to train my AI. Otherwise, why am I doing this? Yeah. And it seems like there's, you listen to Sri, the VC from yesterday. That's what he wants his companies doing. But there's a whole lot of companies that this is a wild west, gold rush. You know, they can't wait to get there, and if they have to step on somebody to get there, it seems like they're willing to do it. And what do you guys do as transactional attorneys? I mean, because, you know, do I guess a couple questions. One, do your clients or do your employers, in your case, John and Tyler, listen to you, or do they tell you, no, we're going to do this, you just have to minimize our risk to the extent that you can, or what influence do you have? John, you want to?
Yeah, it's obviously difficult, right? And it's about building educational awareness as well as trust within the business. And as one of the panels at the beginning of the day spoke of is, I mean, getting yourselves in meetings, getting yourselves in front of the developers so that they know when you say no or, hey, you got to think about this in a different way, that they can trust that you're coming from the right place. Because I'm seeing from a data standpoint, they just want to use all data. I mean, whether it's, market data that we acquire from a proprietary vendor or news articles or these, as I'm sure you're alluding to, is these open sourced data sets, that you may be getting a license to the data set, but the underlying data, there's definitely no license, and they're not warranting that they actually have the rights to leverage or let alone compile that data. It's certainly a very difficult discussion because, as we've discussed already, the business is looking to move as fast as possible to get that AI product.
So what are the most important considerations when somebody comes to you with a deal, whatever the deal may be? Is there a checklist? I have to go through this. We have to make sure I understand the technology. I have to make sure I, obviously read the terms and understand. I mean, what do you go through, Chris?
Yeah, I'll start. I mean, so I think it's a conversation about what are the client's objectives? What are they intending to get out of this? What are they intending to receive from the provider? Have they thought through the considerations of how that's actually going to be actually enabled? How is it going to actually work? Thinking about what intellectual property rights are going to potentially affect this situation, so you can start to, do the mental gymnastics of how you have to plot that out. And then it's down to contractual obligations. It's use rights. It's risk management. It's reps and warranties. It's all kinds of things like that. And the diligence aspects have to be there as well. I mean, I don't want to lose sight of your question a moment ago of the provenance of data rights is something that I do believe is a concern. And as listening to Shree's presentation yesterday, it's that kind of religion that younger companies need to get. And as one of the comments that I was making after the fact is, it would be nice if industry and legal and industry and businesses all work together to kind of create a standard for the provenance of data rights and how we could all start to follow something like that to give startups a checklist. When this is one area of a startup's top 10 list of things they need to be ready for if they ever want to actually get serious investment or sell themselves one day. And this is now on the list as a very important thing. And I think that if you give those folks the right list and tell them what to do and give them the right ways to follow, I think they'll act that way. But in the absence of that, they may just move ahead and go right ahead.
Right, and do whatever they want, and because there are pressures, there's a lot of pressures to get something done. Whether bigger companies chasing the quarter, chasing investment cycles, chasing news cycles, because everybody else in the industry is doing AI, so we need to be doing AI.
But I think a lot of executives that want to do it, but they want to do it the right way. And you can flip that pressure back on the provider because they're trying to hit sales targets, and then you can use that pressure that they're feeling to extract legal protections out of the agreement that they ordinarily wouldn't give because they're more excited to close the deal to get money and revenue.
Right.
And I
So-
would say this,
Go ahead.
one point too is the speed to the transaction, whereas a year ago it might have been we need to get there right now, we have to go right now. I think some of that is flipped a little bit. And I think the buyers of these services have more leverage now, and they have the ability to slow things down a little bit more and take their time and make good informed decisions. Just like Shree was saying yesterday, they're capable of walking away from a company that doesn't have this done correctly. And I think that 12 months ago we would have been talking about the pressure to got to get it now, got to have to test it now, got to be the first mover advantage. Where I'm not so sure that that's the case, and I think people have settled down and have really started to internalize the business risks, and once they're faced with those, they're making wise decisions.
So I have an example of that, if that would be helpful.
Yeah, please.
So we were experimenting with a few different code generators. So we've all seen all the code generators help developers code more efficiently. And the way that these are marketed is that we're going to type something in, create a prompt, and then you're going to get an output or suggestion back. And that's all it is. Totally innocuous, just like how Gmail works. They're nothing to see here. And we, for a few of these tools, we had the teams, our network teams, intercept some of the traffic and decrypt it to see what was actually flying back to the vendor. And it was more data than we understood. It's more than just what you're necessarily typing in. They were collecting contextual information about other things that were open on the screen to help inform the prompt. And so the amount of, I say this by way of saying, you can work through these issues, but the amount of data sometimes involved in these transactions is more than how these sales teams are representing them. It's quite extensive, and it's something that you as a licensee needs to understand, because in a lot of these agreements, you're providing a rep back to the provider that you have full rights to whatever data you're sending to them. Well, how can I rep to that if I don't know exactly what you are sucking up from my system?
So I want to go down that path. I want to pursue this, right? Because when you start talking, the first thing that jumped into my head, and I don't say this in any pejorative way, I'm like, I say it in a legitimately praiseworthy way. Uber is not a taxi service, right? I mean, and it's genius what they do, right? They are a data company. And the way that they get the data that they want, need, use, sell, whatever, is by offering essentially a taxi service, right? But a taxi service is not worth tens of billions or hundreds of billions of dollars in market cap. It's just not. But they're collecting all kinds of information, and now people seem to know it, and they seem to not care about it because you get from point A to point B, and you know, I don't care if you know where I am 3 minutes after you dropped me off. That's no big deal most of the time, right? But when we're talking about individuals getting rides from point A to point B and the information that they might be able to collect from you that you're willing to share, people in your contact list, you know, whatever it may be that they're collecting, that's one set of risks. Very different set of risks if you have a data vendor or AI vendor who is collecting data open on your engineer's computer, who's probably working on proprietary stuff, or at least some stuff that you really wouldn't want to be out there, your competition to have, or anybody to have sometimes. So how do you solve for that risk in an agreement, right? We all know that there's a risk there, a real risk. How do you then, you're alerted to this is going on, maybe you didn't know it was going on before. Do you pump the brakes? Do you say we got to stop using this, and then we got to renegotiate terms? What's the cause of action here?
It's part of your diligence process in entering into this, and that's why I think, to Chris's point, like, executives and companies are more willing to take their time to really understand exactly what's working here and how it's working and what's going on, so that you can solve for these risks, because it's all solvable once you understand exactly what's happening. And maybe it's not going to minimize the risk to nothing, but it's in a way that it is manageable and livable.
So I want to go down the path one more step, because one of the things I said earlier, I may have come across like I was being a little Pollyanna. I should say, oh, everybody's doing the right thing, everybody's moving forward, everybody's changing. But I think what I'm noticing a lot of times, you know, the terms are taken. Here's our contract. You can either sign it or not sign it. We really don't care. You know, if you want Verizon Wireless as your cell phone provider, this is our contract. You don't get to redline it and send it in. You know, you're just like one of the 50 million other people that have Verizon, right? You don't want it, you don't want it. But it seems in this area that there is appreciable opportunity for people like you on the transaction side to mark up things, to raise issues, and they will be addressed. I think that's where I was trying to go with earlier. So how do you do that? How does it go through? What's the process for negotiating or redlining or getting back in touch? Can one of you walk us through that?
Yeah, I'm happy to. I mean, so I think you have to take strong positions in these agreements that are protecting your client's interests, whether you're in-house or on the outside. And a lot of these issues are rooted in the same types of issues that folks that are, you know, lined up against privacy are guarding against. You know, there's very similar things. And, you know, I'm a big proponent of, at least as once we have to know what's going on, and then we have to be able to advise, you know, our business leads on what that means and the risks involved. And then at that point, they're able to make a business risk decision. But I think it's incumbent upon all of us to kind of push the envelope back on the, to make sure that our clients' interests are protected as best as possible. And I'm speaking not only from the customer side, but from the supplier side too. I mean, there's a lot of nascent supplier side here that could easily get pushed around by a big customer too, and they have to be, I think, just as aggressive back on the backside. But like one of the, I think Jason told a story earlier about months-long effort and negotiation with OpenAI, and you have to be able to willing to fight those fights to kind of get to the spot. And again, I think that's what time is now offering companies that it wasn't 12 months ago when they thought they necessarily had to jump into something, but now they have that time to sit there and decide what to do.
And the market here is not settled. So it's like gone are the days of like software license agreements where like the market's well settled on like here's what's industry standard or market for this type of transaction. All of the big providers are competing fiercely for business, and you need to realize they're competing for business. And so, and they can't say, oh, well, this is market. Well, no, it's not, because markets aren't created in 9 months. And so they are figuring it out as much as you are. And so having the confidence of your conviction to push for what you want, especially if you're being reasonable and grounded. Like, hi, I'm not asking you to indemnify me for all the world's harms, but here are actual active claims that are being litigated on this technology. Like, it's more than just copyright. And so I'm not asking you to indemnify and insure against all possible risks and harms, but things that are not academic, they are actually being litigated in real time.
And to that end, like in the indemnification point too, there's some very, very public, very large companies that are promising indemnification for certain things. Peel back the onion there a little bit, right? And take a closer look at what that means and what the terms of those indemnifications actually look like. And they require very specific technological safeguards to be implemented. And that changes the way that some of these technologies actually operate. So, for a lot of these things, you just can't take them at face value. You do have to pull back the layer a little bit and dive a layer deep in to see what's really being promised there.
And that's certainly a difficult conversation with the business, because they say, see the press release, you got, this indemnification. It's like, well, not really, and it is. It's very hard, especially with that pressure coming from the business like that. So.
I think there's so many opportunities in so many places with all of the things that are going on around artificial intelligence, and particularly Gen AI. We were having a conversation before we got up on the panel about the acceptable use policies that are making their ways into these agreements. It's not the underlying license agreement, but it's referring to an acceptable use policy that you have to go find elsewhere. And then there's a host of different provisions that are in there that you have to be very careful about. And then every one of them ends with compliance with the law. Like that's like everybody, and let's all recognize the law is going to change. It's going to be affected in here. And I think that's one of the points that I would tell people is, no matter what we put in these contracts, we're going to have to be adaptable, because there will be swings, and these swings in the law will change how these things may have to be used and what actions we may have to take to unwind certain things too.
The acceptable use policy is a point here that I would like foot stomp, because there are some terms in there. I don't know if the antitrust regulators in the room, but frequently now they have provisions around prohibiting competition. And it is just, it's interesting, and they're changing subtly over time. And so it's something where if you read them, it could really inhibit you, or today and in the future, because the providers, their going out position is that they have the rights to change those unilaterally. I would submit that everyone should try to get those to be static and put some limitations around that, because no one wants to be in the world in which you've just developed something with no intention whatsoever of competing, as you understand the market to be with the competitor or the provider, of them saying, oh no, even though you've invested tens of millions of dollars, you can't do this because it's technically competing with something that I've developed years later. And that is something that a lot of the providers are trying to limit. And so I would look at things like that. The acceptable use policies include a number of provisions that people should push back on, because they're very difficult to comply with on their face.
And I would say you have to go even a step further, not just the supplier's use policy, but the processor's use policies, because they don't always get translated into the agreement that you're signing. And we certainly can find ourselves in a regulated industry, essentially being prohibited from utilizing one of those processes models as a result of those acceptable use policies.
Or seeing a license that said there's third-party licensed content in here, you're going to follow all the rules of the third-party licensed
Yep.
content.
Right, but then
without
you're-
identifying the
without-
third parties
or
and-
the obligations you're signing up for, right?
Exactly.
I mean, that's the thing that, just kills me. I mean, and maybe I should, as a lawyer, I should know more about this, just as a general lawyer. But when you're like, this agreement could change, we reserve the right to change it. We all are used to that, right? Usually it's with privacy policies or things like that, and then. But this strikes me. Can they? Is that actually enforceable when both parties are like this is not like a terms of service. Like, if you don't want to use our website anymore because we changed the terms, then you don't have to. But you guys are actually in bed with this agreement. And can they unilaterally change it and say, oh, we decided that you're not allowed to use this information for this purpose anymore, and you agreed that we could unilaterally change it? I mean, does that work? I mean, it's been a long time since I took contract law.
I don't want to be in the position of having to argue it, because it's like you've got two sophisticated parties. I don't want to go into court saying
Right.
I didn't know what I agreed to. It would just be a really bad look as a practical matter.
Right.
And so there are a lot of the providers are willing to place guardrails on what they're allowed to change, that it won't materially impact in these areas, won't impose additional representations. There are things you can do to really make it livable, and something that if you set up the right governance structures, like Jeff was saying earlier today, to ensure that things are reviewed so that if there are issues, you can respond promptly.
Okay, I mean, this is this is really scary. It's scary simply because I don't think people are paying attention to enough of what they need to be paying attention to, right? I mean, so
That's the big takeaway.
Yeah.
I mean, that's the big takeaway is that there's a lot of landmines in these, particularly about the way that these technologies are being provided through often SaaS offerings or other ways, but that, there's a lot of potential landmines in here, particularly for regulated companies, that are getting involved in and what the providers are doing with their data.
before we go down that path, because I mean, I can't imagine, oh my God, when you have regulators to deal with this on top of all this. But Jason brought up something about that you just mentioned, Chris, about how when you're doing these deals, you gotta know what your terms are with people, and then you have to know what the people who are your vendors, what their terms are with those same people, because you may not be giving them the data, Tyler, as you were just talking, the data, you've carved it out, you can't collect that from us. But if one of your vendors for a different product has a deal where they're able to collect certain information and use it, I mean, that can really come back to haunt you, right? Because essentially, the way I look at these contracts and relationships is it's only as strong as the weakest link.
Right.
Right. So if you have a vendor that's a weak link, then all your data or a big chunk of your data could be just siphoned off without you even knowing it's siphoned off, and you're living with the belief that you're protected because you have a good deal with OpenAI, for example, right? How do you solve for that when you're writing these contracts, negotiating these contracts, and is there some kind of flagging mechanism or a checklist that I always want to see what the vendor's agreement is with OpenAI, or what the vendor's agreements are before you sign off on them using it? Or, I mean, how do you make sure you're not falling prey to that problem that Jason identified?
It depends, because it depends on the service provider and then the sub-processor. Some of these tools have the ability to opt out, like there's configuration settings. And so it may not be a contractual mechanism. I don't care if their contract's is good, as long as they've configured the underlying AI service they're using in a way that I know, because of my knowledge of the system, will prevent it from doing something that I find to be malicious or harmful. Or there's, in some certain circumstances, them repping two things in a contract, that they have certain things with their vendor. I try not to look at agreements because they tend to be someone else's confidential information. And
Right,
so,
right. So, and that's the thing. I mean, how do you know? I mean, how do you really know? I mean, because it seems to me like even if so there's a lot of people that don't even know that they should be looking at a lot of these things and are just clicking or agreeing or what. But now you've done it responsibly. You've set it all up, and then now you're entering agreements with people who haven't done it responsibly. I mean, maybe that's the place to take the regulation conversation, John, because you have to have that in your mind, right? You can't be dealing with people. You're regulated
Yeah,
heavily,
very heavy.
and you can't be letting information that your regulators won't let you share with others getting siphoned off by other people unknowing to you.
Yeah, no, that's absolutely right. And I mean, obviously, contracts can just go only halfway, right? I mean, it doesn't matter what you put into that agreement. I mean, respectfully, I mean, technologists, especially CTOs, are probably looking at those contracts and they're doing what they want anyway. So what I think is most important is complementing that contract with a sufficient supplier due diligence program, right? A program that not only is looking at the suppliers on a periodic basis, whether it is quarterly, yearly, so on and so forth, and asking the questions, conducting the reviews, doing what is necessary to glean information that you may have not received initially, or that has changed, right? As we've discussed previously, I think it's extremely important that we, in these contracts, get that notice requirement. Anything changes in the way that you're utilizing AI, you need to tell us so that we can then conduct further analysis on that to see if it is aligned with, you know, our internal policies, our regulations, so on and so forth. But then I also think it is it is required on us, incumbent on us, to also put in the right protocols on our side. I mean, call it a gatekeeper, if you will, ensuring that before any data is piped over that way, that it goes through some type of filter that, whether it's through labeling or block and deny lists or classifiers or something, to prevent the unintended disclosure of information that shouldn't be going to that vendor. So yeah, we have obviously a lot of different security measures, different controls when it comes to the vendor, but at the end of the day, it's very difficult to get 100% compliance.
The ongoing vendor oversight can't be overstated because you do the diligence initially, but these are evolving technologies and these models are maintenance. So I don't just care about how it is today, but in the future. And so one of the ways that one of the tricks I'd like to use is when I have the leverage, force the provider to add controls that are audited by their independent third-party auditor. Yep. Like, if you're telling me and promising to me you're not improving your model with my data, well, there better be controls in your SOC 2 Type 2 that Ernst & Young or someone is testing to give me additional assurance that that's actually the case. Or, if I care about the vendor contract, ensuring that Ernst & Young is looking at that vendor contract, that it has the right provisions in place. And I actually find vendors are open to that discussion because they realize it's not just a Capital One or regulated financial industry interest. Every customer you have is going to have the same issues or concerns. And so if it's in there, it actually decreases the time they have to worry negotiating it with me or someone else because everyone's interested in it and they can just turn over an audit report.
Yeah.
And it becomes a competitive advantage at that
Yeah.
point. I mean, for the reputable.
See, that's what I was just going to say. I mean, this is why, again, it's very important to know who you're doing business with. You know, and no offense to youngsters who just graduated from college last week, but if that's the person who is starting the AI company that now you're looking at doing business with, maybe you shouldn't be doing business with him, right, John? Because you are heavily regulated, and they probably have no idea about that. So how important is reputation to you?
I think it all depends on, it goes back to like step number one, which is what are the objectives, right? What are we doing here? How risky is what we're trying to actually accomplish? Because I think there are some things where you can accept more risk and take a flyer on trying out a brand new technology because it may deliver something versus you're seeking to use it in a way that you're going to be analyzing data, you know, looking for signals, and you know that it's going to be, you know, you might get an examination on what you actually did there. So you have to have a whole different set of risk measures, risk mitigation measures in place. So I think it goes back to step one of what are we doing and what level of risk can we accept with a particular deal. Even with a regulated company, there may be use cases where you can accept more risk and can take a flyer on that nascent company.
But you have to really also know what they're getting access to, right?
Of course.
Right,
Yes.
because the fact that, oh, well, this technology is only going to help our people keep their calendars updated and current and across the whole team so everybody knows what everybody's doing. That's great. Well, but if it goes deeper dive into what you've got going on in your machine and is siphoning more information out because you've given them permission to do that, then that's a whole different level of risk. So really, understanding the technology is critical, right? You all agree?
Yeah.
And your reliance on it, like the business processes that it's supporting.
Okay. All right. So now, it's hard to believe we've been going for about 47 minutes, 48 minutes here. There's one thing that we had said we wanted to talk about that I want to make sure that we have time to get to. And it's because I like lists and people like lists and they want to remember lists. And it's, what are the top 3 tips for an AI machine learning type transaction? So what are your best tips that you want people here today to remember? Chris, you want to lead off on that?
Yeah, I'm happy to. I think the things that a lot of the things that I think we've already talked about, but just to kind of recycle those, again, you can't understate the importance of diligencing the counterparty here, understanding what's going on with how they're actually delivering these services and what they intend to give to you, making sure, scary situations like all the data on an open screen are not being sucked in when a client is actually delivering an input to an AI system. I think that's vitally important. I think that would be probably number 1 in my mind. I think the other things that we haven't talked a lot about, but really understanding what the IP rights and the allocation of those IP rights are going to look like at the end of the day, and making sure that those line up with your business objectives. What are you planning to use this for, and how much do you need to be able to say at the end of the day that you own that? Those are the 2 things that I would say I'd be focusing a lot on.
Okay, great. John, Tyler, John, go ahead.
No, absolutely. I mean, to continue on that train, I think it's very important just to know where your data is being processed. The location. That's what I wrote down because, there's multiple different ways that that your data can be processed, housed. I mean, there are private tenants, there's shared tenants, tuned shared tenants. I mean, all of these, have implications, different risks that you have to be aware of. So fully understanding and appreciating where your data is going. Is it going to a static model? Is it going to a dynamic model? I mean, I think those are extremely important because, as you know, dynamic models have much more of a risk, high enhanced risk profile than a static model. But we also have to appreciate that even if it's a static model, that does not necessarily mean they're not training a dev version of that model for a future iteration. So that would come to the second, and the second being is having those usage restrictions, not only on the inputs, but also the outputs and the feedback that you may be implemented into the system, whether it's the thumbs up, thumbs down, any textual feedback that you're adding. All of that could be leveraged by the provider in a way that you don't foresee or let alone want, right? So fully understanding and appreciating that is certainly important. And then I wrote down acceptable uses policies. Knowledge is power, fully understanding, each and every acceptable use policy, trying to get those codified into your contract rather than relying upon online policy is obviously best practice. So not always possible.
Great. And Tyler, you're...
So yeah, to add on to some of what was said, the diligence, I love taking the diligence responses and throwing those into representations. Because at a lot of these companies, that's going to trigger a heightened level of diligence that I know a lawyer is going to be looking at those representations and substantiating them before they agree to them, just because of the risk if they're not true. And so I love doing that. I also love pushing. Somehow people have thought it was okay just to give a defense obligation instead of a true indemnity. I'm an indemnity purist. I like to be held harmless and have a full indemnity, not just a defense and payment obligation. So if we could all band arms together and agree to that, I think we'd all be better off. And then these services, some of them are changing.
Yeah.
And so figuring out like what are you going to need from a compliance perspective? Are you to satisfy your own compliance processes? Or you need copies of artifacts of the changed model over time so that you can evidence and explain how decisions were made or weren't made. And then also, how are you going to respond to those changes to ensure it's not going to disrupt business outcomes, depending on how you use the tools at hand? And so these tools might create a lot of efficiency in some ways, but it requires a lot of governance to ensure that you don't have unintended business outcomes.
I think I only gave 2, but I want to make sure I go back and give one more.
Sure.
I would say to everyone, I think just by virtue of being in this room, you have a higher level of knowledge of this subject matter area than probably most other people, but you probably work with people in your organizations or your law firms or wherever that are starting to touch these issues that perhaps maybe they don't fully appreciate all these issues. So I would suggest to you that you should be advocates of kind of spreading the word about, what these risks really look like and how it's very important to understand what the underlying technology is here and how it's going to be implemented. I mean, John was just mentioning static models, dynamic models, tune sharing, and SaaS models where all the data is stored in one area, but your data is all being used to tune a single model, and concerns. I was perked up during the antitrust presentation when we talked about all training on similar models. I mean, because that's a very specific architecture that a lot of companies are trying to leverage right now to save money. So I think it's very important to understand the technology. I think this room is well above grade already just by being here. But please, I would say, be advocates of helping others that are going to be touching these spaces to understand this, so they don't, create foot fouls for your clients.
Yeah, that was with the antitrust panel. That kind of perked my itch. I think I heard him say, and I got to go back and listen to the tape, but if you're all using the same models and you're all using the same data, that's a flag that DOJ is interested in looking at. And I'm like, well, Jesus, isn't that exactly what is going on right now in a lot of respects? And I guess it's not that it is going to be a problem, but that would be one very easy, creative way to collude without really. You wouldn't even need to wink or nod because it's all behind the scenes running on machines.
I'm pretty sure I've seen in not too recent past, like articles from technology companies that explain how to set up, SaaS architecture exactly like that. And I don't know. I'm not an antitrust lawyer.
No, I'm not either. But that was that was
caught
interesting.
my attention.
Yeah, that was very interesting. And speaking about that, so that is a risk that I think hopefully everybody here has had their eyes open to. And to go back to what you were just saying, Tyler, about indemnity purists, what should an indemnity agreement look like? And maybe we talk about it like in a certain context, given the time that we have left. Like for IP, and we all hear, we'll indemnify you if you're found to infringe copyrights if you use our model. Well, it's not quite that simple. That's a nice title for the press release, but the terms aren't that. They're just not. They're very specific. And it's not that they won't indemnify anything, but they indemnify a lot less than the title that the press release suggests. Mm-hmm. So what should you be keeping your eye on in that scenario when you're looking at those indemnity agreements? What do you want to see? Tyler, we'll start with you first.
Read all of the complaints of all the litigation that's going on. I think there should be a 1-to-1 correlation. Each complaint should have a corollary or a corresponding indemnification protection, more than just copyright. And I also think side note, I do think the complaints are really helpful at illustrating some of the potential risks. Now, whether or not the allegations are true, I can't say, but it forces you to think about these things in a slightly different way, and so it's very illuminating. The restrictions on someone's obligation to indemnify you, it's not uncommon in commercial agreements for there to be exceptions, because it would be unreasonable for someone to indemnify you under all circumstances, but pay particular attention and to think through and game out with your litigation team how this could come about so you don't find yourself with a meaningless indemnity. And then I would also don't agree to a defense claim, like a defensive claim in payment. Like, it's just not, it's nothing.
Yeah. No, and I mean, I think it's very important. You know, you go through this, well, we want to indemnify you if somebody's done something criminal or intentional or, you know, that sort of thing. And some of those, they also will talk about, well, if it was misappropriated. Well, geez, just based on the last panel we had with trade secrets, I'm not convinced I know where the definition of misappropriated is going to be once the AI trade secret cases unfold. At what point, so like my mind, at what point has it been misappropriated?
You raise an issue we've had mixed success with, but forcing the vendors to be more transparent about the actual risks as they see them in these areas, so you as a customer can make informed decisions. There's an asymmetric information problem. And so as they learn more through the course of litigation of the potential infringement risk, if they want me to take on some of that risk, they need to share information with me so that I can make an informed decision.
Right, and that's almost like an insurance policy, right? And, you know, if something's going to happen, you have to mitigate it on your own, and you got to let us know. You know, you can't let and I know, like, we moved into this space 18 months ago. And one of the things that just popped in my head in the agreement is if you have water damage and you notice mold, you have to say something. Right. You can't wait a year or two and say, oh, the whole wall is condemned, the whole place is condemned. No. If you see it, say it, right? Because you can do something about it. When it's one little piece of mold and a little wet drywall, very easy to fix that. When it now becomes a part of the structural problems, that's not easy to fix. So that's good advice. Chris, you have thoughts?
I'd be wary of the carve-outs to indemnity. I mean, again, there's, you know, and these are often a legacy of the IP indemnity carve-outs, you know. If you combine it with anything, if you modify it in any way, if you do X, Y, Z to it, you know, those are all the things you're intending to do with the AI technology, likely to make beneficial use of it. So, you know, if that is the case, then what is the impact on your entire indemnity provision? The other thing I would say too is be very wary of the disclaimers of the very, you know, special consequential damages and things like that. Be very wary of giving those up if you're on the customer side.
Yeah.
Great, John.
I was gonna just first 100% agree with that. Like, those standard carve-outs you can't gloss over. You know, this is not a regular technology. Those are gonna happen, combining especially. But I mean, I would like to reverse the script. Sometimes we see that they want us to indemnify them for our customer content that is, you know, put into the systems, right? But if you're not 100% careful, remember, in many of these agreements, the new standard, right? There's no industry standard, but output can be owned by the customer, right? But they're incorporating that into a definition that is customer content, which then we have to indemnify for. So just, again, remembering how important it is that terminology can make or break many different provisions in an agreement, and that you certainly want to, you know, understand, and it may be reasonable that your input doesn't infringe upon third party, but not your customer content, which could include your output, which you have no control over, right?
Right, right. So we're at 3:20, but I'd like to give each of you a very rapid fire approach here. One final thought. If people remember only one thing, what of the many good pieces of advice you've bestowed on us here do you want them to make sure that they take away and tell others? John, we'll start with you.
I think the one thing I would say is, honestly, you just can't trust the salesman at the suppliers, right? And honestly, you can't.
That's always good advice.
Yeah, and honestly, you can't trust your business folks either, because they are interested in this, but they may not fully appreciate all of the intended consequences at the end. I can tell you it happens several times. Like, I already protected. We have these robust security measures, these robust confidentiality measures. Like, what else does AI add? And as we all know and appreciate, there's a lot more that needs to be considered with an AI transaction that a typical data transfer or technology agreement does not.
Great, thanks a lot, John. Chris.
Invest the time to understand the technology so that you can give the right advice.
Awesome. Tyler.
These are not cruise control transactions. They require lots of engagement from the lawyers. And don't be afraid of asking questions. Questions, questions, questions. There's no such thing as a dumb question because they reveal a lot of risks that cynically I think sales teams are trying to get us to gloss over. And so, yeah, asking questions is it's like law school 101. The more questions you ask, the more you're going to be able to serve your client.
Right. Trust but verify.
There you go.
All right, everybody. Thank you so much. That was a great conversation. All right, so we'll take.